Thank you, Justin. All of us at BJI are really grateful to all of you for spending time with us today. Please forgive a brief and I hope painless advertisement for Berkeley Judicial Institute before we get started. Now that we have you here, whether it's your first time or one of many, we would love to have you back. You'll notice in the chat that Justin has just popped in several links. Check out our webpage where you'll find registrations for future programs, recordings of past programs, interesting things to read. Join our mailing list. Follow us on social media. All right, advertisement over. And on to our main event. Justin has also put in the chat biographical links for our spectacular faculty. And it's my belief that people would rather spend their time talking than hearing how wonderful they are, at least in a public setting. In a private setting, people are pretty comfortable hearing how wonderful they are. But speaking of that wonderful faculty, it's my great pleasure to introduce Helene Krasnoff, who serves as Director of Environmental Law Institute's Climate Judiciary Project. There, she's responsible for the leadership, strategy, and management of that project. And she'll moderate this conversation today. I'm very grateful to Helene and her wonderful colleagues for their work in this area, and grateful they're sharing that work with Berkeley Judicial Institute. So Helene, where will we start today?
Thank you, Denise, and thank you to BJI for inviting us here and all of you for joining on a Friday afternoon. I'm Helene Krasnoff, as Denise said, with the Environmental Law Institute, and I'm joined by some of my colleagues here. And our goal today is to introduce you to the Climate Judiciary Project and ELI. There's a lot of acronyms, CJP, as we call our project. For those of you who aren't familiar with ELI, it was founded in 1969 as, and remains today, an independent, nonpartisan environmental research and education institute. ELI is trusted by government officials, environmental and business leaders, academics, members of the environmental bar, and journalists as a source of impartial analysis on all sorts of environmental issues. As part of that work, ELI has decades of experience providing judicial education to judges both in the United States and internationally. As you all know, judges are encouraged, and in many cases, actually for state court judges, required to participate in judicial education. And judges have made it a priority to learn about new technical topics that are influencing legal trends. And one of those trends, which my colleague Jared Page will talk about in a little bit, are cases that raise issues of climate, law, policy, and science. So that's where CJP comes in. CJP began in 2018 in coordination with the Federal Judicial Center in response to interest from the judiciary in learning about climate science. We continue to partner with leading judicial education institutes such as the National Judicial College and state judicial authorities to provide education through their established programs. Our programming is based in consensus science, and it provides factual information about climate science and how it's arising in the law. CJP does not itself participate in litigation. It doesn't support or coordinate with parties in litigation. We do not advise judges about any given case or how to rule in any given case. We are, again, providing scientific background to judges on an emerging trend. I'm going to tell you a little bit about our programming, and we are very lucky today to be joined by Oregon Supreme Court Justice Rebecca Duncan, who has participated in and organized some of the events I'm going to talk about. So in particular, Justice Duncan was a participant in a collaboration we have with NJC, or the National Judicial College, more acronyms coming, that we call the Judicial Leaders in Climate Science Program, or JLCS, which Jared and John will tell you I have a terrible time getting those letters straight, despite our program. JLCS. The JLCS, Judicial Leaders in Climate Science, is a year-long program for state court judges. The judges are nominated by their chief judge to participate um, through NJC, and it is a year-long program. It has 2 in-person engagements, and it focuses on judicial leadership skills training integrated with climate science topics. So Justice Duncan, this is a map of our participants to date. Justice Duncan was one of 23 participants in our first cohort of JLCS. And we are now working with our second cohort of 14 judges. So the striped states are where we have people in both cohorts. The 3 new states in yellow are the new states in the second cohort, and the remainder, the green, are the first cohort. And this program has enabled us to reach more judges because they are leaders. That's the leader part of judicial leaders in climate science. And leaders like Justice Duncan have gone back and organized climate science events in their own jurisdictions. So Justice Duncan is going to tell us about her event, but Oregon is far from the only state where there have been events for the judiciary statewide. Others that held events last year include California, Indiana, Kentucky, New York. There was just an event in Puerto Rico a couple weeks ago, and there are more planned for this year. We have also, separate from the JLCS program, have worked with NJC on a number of webinars that are available to all judges, where leading scientists have presented on topics that have included hurricanes, sea level rise, and most recently on the 5th National Climate Assessment. In addition to our work with these judicial education institutes at CJP, we recently participated in a meeting of court-appointed neutrals. We've worked with local bar associations. We are right now planning our first international program for Europe in the fall. And so that is some of our programming that we are very proud of and have continued to do. So feel free, we'll give you the stuff at the end, but to reach out if there's programming that you would like us to be a part of. But I also want to make sure that you know about our curriculum. CJP has developed a climate science and law curriculum in collaboration with leading climate scientists and legal experts. It is publicly available on our website. It is called the Climate Science and Law for Judges Curriculum. It also rolls off the tongue, no acronym. I think no acronym. Maybe we should make one. There are currently 13 independent modules in the curriculum. They are authored by leading experts in their respective disciplines. As you can see here, there are 7 science modules and 6 legal modules. You can see them here by topic. How these came about, in order, we identified authors, the authors are on the modules, and then to enhance accuracy and provide an opportunity for additional feedback and experts to weigh in, each module underwent a peer review process as well, usually by 3 reviewers. The curriculum is meant to introduce the fundamentals of climate science and the law, as well as relevant aspects of cases involving scientific evidence. As I said at the outset, the material does not tell judges how to rule in any given case on any legal questions or legal issues. It is just factual information about how climate science is arising in the law. And the climate science is, again, as I said at the beginning, a consensus science, and it's grounded in reports and assessments from groups like the U.S. Global Change Research Programs, the National Climate Assessment, which I referenced. We've had a webinar about the most recent one, the U.S. National Academies of Sciences, and the World Meteorological Association's IPCC, or Intergovernmental Panel on Climate Change. So we're going to actually do a little show and tell here and walk through. This is static because we're using slides. You can obviously go to our website and do this for real, but look at how this actually works and how you can access these materials for a couple of minutes. On our homepage, which is cjp.eli.org, which we will show you as well, there's a curriculum tab there, which has helpfully been highlighted for you. And if you go to the summary, that's circled there, it will take you to all of the modules. So what you can actually see here are the first 6 science modules, because that's all that fit on a slide. But I want to direct you, well, so you can see some of the topics here, things like what is causing climate change, the risks and costs of climate change. But I want to direct you to the 2 arrows. So the top arrow is a slide presentation. that covers all of these topics and will be actually in some ways similar to the slides that Jared and John are going to go through shortly. And the second arrow shows you the link, which will pop open the module. There's a similar one for the law, and there's also a slideshow that goes with the legal modules. So if you open the module, in this one, we open the impacts of climate change. You will see there's an executive summary. That's it is the middle of the three boxes that are highlighted. And so each module has an executive summary. If you want to check out what's in here, do I really want to read it all? And then when you find that you do really want to read it all, you can download it. That's one of the options there. And then also you can navigate through the sections of it on the right if you have just a part of it that you're interested in. We are currently updating some of these modules. This was completed in 2023, the 13 modules. So we're doing our best to update as much as we can. And then we are also adding some new topics along the way. So I'm going to stop talking about what we do, and we're going to do a little exercise for the next 15, 20 minutes and show you what we do. And so my colleague, Dr. John Doherty, is going to provide a little climate science 101 for you all. And then Jared Page is going to talk about how this science is arising in the law. Justice Duncan will then tell us about her experience with CJP. And finally, we are lucky to be joined today too by Joy Lingar, who is NJC's Chief Academic Officer, and she's going to just provide some closing thoughts, having worked with us. And there will be time for questions. So, of course, again, this is just a brief introduction. We are happy to talk with any of you about participating in your events, either by us speaking at them, or we also are happy to work with you to find local scientists who could participate at your events. And to educate your colleagues about climate science. So here you have how to reach us, and I'm sure we'll provide that again. But with that, I'm going to turn over to John for some Climate Science 101.
Thank you, Helene, and thank you to the Berkeley Judicial Institute for the invitation. It's my pleasure to be here and introduce a little bit of the climate science. Here I'll be talking about what we know and how we know it. And I'll specifically cover Earth's energy balance, a little bit on the impacts of climate change and their attribution, and solutions to the climate problem that have started to be studied and implemented and proposed. So Earth's energy balance, what does that phrase mean? Well, the global mean surface temperature of the planet is fundamentally set by the balance of energy that the planet receives by the sun and the amount of energy that can escape through the Earth's lower atmosphere. You'll see on this schematic that there are a variety of fluxes that affect these processes, but I want to draw your attention to this layer of gases in the atmosphere called greenhouse gases. These are gases most famously like carbon dioxide or CO2, but also include things like methane, nitrous oxide, water vapor, and a variety of others. And what these gases do is they act like a blanket in the atmosphere. They don't provide any additional warming themselves, but they make it more difficult for heat to escape the Earth's lower atmosphere and result in a warming of the lower atmosphere and the surface of the planet. These gases exist in nature, but human activity has been responsible for increasing their concentration over the last century or so. Okay, so we know that human activity has increased the concentration of greenhouse gases in the atmosphere. At the same time, our temperature observations, the black curve depicted here, tells us that the planet is warming. But lots of things could theoretically influence climate change. So how do we actually know what the cause of this warming is? One of the ways that scientists can get at this is through computer simulations of the climate known as climate models. And models allow us to ask the question of what would the temperature evolution look like if we were to take out human activity? That is, if we just had natural variability, solar changes, volcanism, et cetera, what would the temperature of the planet look like over time? And if you're the Intergovernmental Panel on Climate Change, or IPCC, which is the world's leading authority on the science of climate, it is the UN's official body for assessing comprehensively the science of climate change as it's understood in the entirety of the scientific literature. You get the luxury of looking at about 100 of these climate models, which are constructed independently by different research groups from around the world. And you can run all of those models together with and without human influence on the climate system. What I'm showing here is a figure from the most recent IPCC report, which was released between 2021 and 2023. And the green curve represents what we would expect the global mean surface temperature change to look like without any human influence. The tan curve represents what we expect the global mean surface temperature to look like when we do include human influence in the models. And we just cannot reproduce this warming trend without human activity. This is one of the key pieces of evidence that allowed scientists working on the most recent IPCC report to conclude that it is, quote, unequivocal that human activity is responsible for this warming trend. Now, there is disagreement between these models. That's the lighter color shading that is kind of enveloping these lines here. But if you look on the whole at the model average, you can see that the trends are just about the same. So why should anyone actually care about a warming of the planet? The answer is that with additional warming comes climate risk. And when I say climate risk, I'm really talking about three things. I'm talking about climate hazards, which could be something like sea level rise. I know it's hard to see on this image with the black color on the blue background, but that says sea level rise under hazard. I'm also talking about exposure, right? So not everyone is exposed to the hazard of sea level rise, but if you, for example, live along the southeastern coast of the US, you are exposed to that hazard. The third thing that I'm talking about when I say climate risk is vulnerability. So people who can't afford to evacuate, for example, from a flood that was made worse by a baseline increase in the ocean along the coast might be disproportionately affected by the risk of sea level rise in a way that people who can afford to evacuate from that flood event are not. And when we talk about climate impacts, it's important to note that climate change affects different groups of people differently. The first example that I want to illustrate this with is the generational distinction. So what I'm showing here is another plot from the most recent IPCC report that illustrates cartoon schematics for two generations, one born in 1950 and another born in 2020 on the bottom. And warming will increase over time. The risks will get more intense and more frequent over time. And so someone born today will suffer more from climate impacts than will someone born in 1950. This is a totally non-comprehensive flowchart that illustrates some examples of these climate risks, vulnerable groups, and potential reasons for why those groups might be vulnerable. So for example, heat waves might disproportionately affect children because of their higher risk of heat stroke. Drought might affect rural communities because of their economic dependency on irrigation for agriculture, et cetera. And when we look at economic impacts across the whole of the United States, here is a plot from the National Oceanic and Atmospheric Administration, or NOAA. And what this shows is both the count and the cost of United States CPI-adjusted billion-dollar weather and climate disaster events. This isn't just climate hazard, this is also climate exposure, right? This isn't just climate change impacts, but it's also kind of us moving in the way of climate change. So both of those things together are making these events more costly to society. Okay, over the last 2 decades or so, there's been a real movement in the climate science community to focus on this field of research known as attribution science. And attribution science is becoming critical to legal decision-making as well as policy planning around climate adaptation and mitigation efforts. So I wanted to just spend a few minutes unpacking what we actually mean when we say attribution science. It's actually 4 independent kind of categories of research. The first that I'll talk about here is source attribution, which aims to quantify the source's emissions, essentially looking at the greenhouse gas emissions. How much emissions did this state or city or even company or sector emit? The next stage of this attribution science process is to do global climate change attribution, which looks at the connections between emissions and a change in the global climate system. This could be through an increase in global mean surface temperature, or also looking at things like sea level rise or even a reduction in Arctic sea ice, tying the emissions to the impacts on the global climate system. The next two categories of attribution science are related: event attribution, sometimes also called extreme event attribution science, and impact attribution science. Event attribution science, or extreme event attribution science, looks at the impacts of climate change on the intensity or frequency of extreme weather events like a drought or a heat wave, for example. And impact attribution takes that one step closer by looking at the actual harm felt on the ground from that event. So, for example, an impact attribution study might ask the question, how much economic damage was caused by that drought event, which was intensified by climate change? So these four buckets of research together kind of paint the causal picture between the emissions of a particular source to the impacts climate change felt on the ground. And the number of attribution publications in the scientific literature has skyrocketed really just over the last 3 years. So this is kind of a rapidly growing and new area of research that has a lot of potential to inform both litigation and policy making around climate adaptation and mitigation. Speaking of mitigation, many states and cities have put mitigation plans in place to reduce their emissions and try to avoid the worst impacts of climate change. Many of these states and cities have also started putting adaptation plans in place to adapt to the impacts of climate change that can't be avoided through emissions reductions, right? There's a certain amount of climate impacts that are kind of already locked in, and these states are looking to adapt to those changes. Now, I don't need to tell this audience, but when the government does anything, of course, there are going to be people on both sides that are arguing that it's the wrong way to do things. So you will have people, I'm sure, filing lawsuits that are saying the governments are doing too much on climate change and that the governments are doing too little on climate change. So lots of these plans are, I'm sure, going to be challenged in court and will be kind of coming to your courtroom, as my colleague will be discussing in a little bit. But before I leave it to my colleague to talk about climate science in the courts, I just wanted to make you aware of a few resources that went into this presentation. The first two are kind of the ones that I drew most heavily from: the Intergovernmental Panel on Climate Change's Sixth Assessment Report and the US Global Change Research Program's Fifth National Climate Assessment. A couple other resources down here as well, should you be interested in exploring them further. And I'll be happy to take any questions at the end, but first I'm going to hand it over to my colleague, Jared Page, who's going to tell us all about how climate science is coming to the courts.
Thanks, John. And thanks, Helene, and thanks to BJI for hosting us today. So, as John mentioned, I'm going to speak a little bit and briefly about the connections between the climate science and climate change and the courtroom. Where does all this information in my presentation come from? Columbia Law School's Sabin Center for Climate Change Law actually maintains a database of these cases. There's a US database and there's an international database. You can search these, you can filter them by claim, by jurisdiction, by date filed. And the cases include brief descriptions or summaries and many documents from the cases as well. And this is open to the public and you're free to check it out at any time. How many cases will you find there? So as of last month, April 2024, there are more than 2,600 cases on both the US and global databases. I just want to make two quick points about this slide. The first is the overall trend, right? You can see that in terms of the number of cases filed, there's been an increase from about a handful of cases or so filed each year in the early 2000s to a few hundred filed each year in the 2020s. The other point to make about this slide is that it's the US courts where most of these cases are being filed. Let's look a little bit more closely at where these are being filed. So as you saw in the previous slide, right, the US is where most are filed. Australia is a distant second, and the UK is a distant third. So I know this isn't legible, but that's okay. It's really just meant to show, again, the sort of US proportion, which you can see is around 70% of cases worldwide. But the other point to make is just how many jurisdictions are involved here. So there's more than 55 countries represented on the database, and there's also international and regional bodies, like the European Court of Human Rights, for example. But if we drill down a little further into the US, so of those US cases, here's where they're located. And you're looking at cases filed in state courts and in federal courts. And I just want to pause for a moment on this slide to note the asterisk here. Number of climate cases, right? So this count is based on the definition from the Sabin Center, which you saw briefly on the other slide, and I'll just explain now, is based on two criteria. So first, in order to make it into the database, a case has to be before a judicial body. So investigations and some administrative proceedings aren't included. And the second criteria is that climate science, policy, or law has to be a material issue of law or fact in the case. So with these two criteria, it likely means that this map is sort of undercounting and underrepresenting the impact of climate change in terms of litigation. So it's not only because of sort of challenges with collections, particularly finding and collecting cases at the state and local levels, but also because the map doesn't include cases that have a direct impact on climate, but don't necessarily raise climate issues. So challenges to permits for fossil fuel related projects, for example, weather and climate hazards like hurricanes and the insurance claims that they can generate are similarly not represented here. I know following Hurricane Maria in Puerto Rico, there were sort of thousands of some of these types of claims filed, and these aren't represented in the database or on this map. I think the main point to take away from this map here is even within the relatively narrow definition of the Sabin Center's database, we're already seeing direct and express consideration of climate, including climate science, in practically all 50 states. It's only New Hampshire doesn't have a climate case represented in the database at this point. So we know there's thousands of cases, but what are they about? What are the claims that they relate to? Well, there's really no typical case here. These cases involve constitutional, statutory, regulatory, administrative, and common law claims. The most common cases you can see are brought under the National Environmental Policy Act, and similar cases brought under state environmental review laws. And when it comes to the science, actually, cases brought under the Endangered Species Act are some that discuss science actually in the greatest detail. And before I move to the next section, I want to leave you with another way of thinking about how climate is coming up in the courtrooms. So professors at Northwestern Law and Melbourne Law in Australia offer a concentric circle approach. So this isn't the one used by the Sabin database, but it shows that climate change can drive litigation in many ways, sort of from the inner circle where climate is a central issue to the outer circle, where it might not come up directly in the case, but has many implications for climate. And there's a lot in that outer layer, and science can be relevant in those aspects too. So you've seen some examples of what the current issues are, what the current claims are. I just want to take a moment to look ahead to what some of the trends are on the horizon. So at the federal level, sort of John was getting at this with some of his comments, but litigation over agency regulations, for example, is often a given. Most new or significant rules are challenged by litigants who either want more and or less stringent approaches. I just note here that the relationship between agencies and climate actions is expanding. And we're no longer seeing just environmentally focused federal agencies announcing and promulgating rules, regulations, and guidance on climate change. It's now agencies like the Securities and Exchange Commission. They recently announced a rule about the disclosure of climate-related risks. That rule was immediately challenged, and the SEC has voluntarily stayed it in early April, pending resolution of those legal challenges that are currently consolidated in the Eighth Circuit Court of Appeals. A second category in terms of trends are renewables. And we've seen many challenges related to wind turbine siting, the wildlife and environmental impacts of installations, contracts, permitting issues, cases related to rate structure and setting. And in 2021 and 2022, two laws were enacted that may catalyze additional litigation. The Bipartisan Infrastructure Law and the Inflation Reduction Act, or IRA. So the IRA in particular, it's injecting unprecedented dollars on the order of hundreds of billions to accelerate a clean energy transition. Many of those dollars are going to state and local communities, and they're being put towards projects. And as many of you know, each project, of course, comes with its own set of potential legal obstacles that all may result in litigation. There's also a growing number of cases, now up to around 30 or so, filed by cities, counties, and states against energy companies. These cases have been filed mostly in state courts based on state law claims, such as consumer protection, failure to warn, and on torts like public nuisance. And until recently, the cases were involved in jurisdictional disputes about whether they were properly heard in state court or federal court. Unanimously, federal courts of appeals have concluded the cases are properly before state courts. However, in one of the cases brought by City and County of Honolulu against Sunoco and others, there's a pending petition of certiorari before the U.S. Supreme Court. Many will be watching closely to see whether the court grants this petition and on what question. The last trend is state environmental rights amendments. So these are provisions in state constitutions that guarantee some form, some variant of a right to a clean and healthy environment. So there's currently a handful of states with these, but more than a dozen other states, including California, have proposed amending their constitutions to include one of these ERAs, these environmental rights amendments. New York was the most recent state to add one in 2021, and there's already been cases filed based on that provision in New York. And actually, an environmental rights amendment was a central feature in one recent Montana case, Held versus Montana. So, talking for a moment about how climate science can come up in these cases, it can come up in sort of fairly direct ways, like when climate scientists testify at trial. And I think probably the most well-known example is the case that went to trial last year, Held versus Montana, as you see here. So the case was about a provision in Montana law, the Montana Environmental Policy Act, that governs environmental reviews. Although unlike in some states, like California, for example, that require the consideration of greenhouse gas emissions, the Montana provision barred state agency officials from considering and evaluating greenhouse gas emissions and other climate dimensions when they were conducting environmental reviews. So 16 youth filed a lawsuit arguing that the provision violated their rights under the state constitution. And Montana's constitution does contain an environmental rights amendment, guaranteeing a right, as you can see here, to a clean and healthful environment for all Montanans. The plaintiff sought a declaratory judgment in the case, and after a trial in which numerous climate scientists testified, a Montana judge issued a 100+ page opinion that included nearly 1,000 references to climate science. So the factual findings from climate scientists you can see here, along with language from the opinion. The two on the end from Dr. Stephen Running and the factual findings from Dr. Lori Byron and Dr. Elise Van Susteren, those were not contested at trial. The contested bit here had to do with whether Montana's emissions were significant enough contribution to the undeniably global problem of climate change. The defendants in this case testified that those emissions from Montana were not significant enough, but the trial court disagreed and found that Montana's emissions were significant, both in terms of the overall emissions and per capita emissions. The case is currently on appeal before the Montana Supreme Court. Final briefs in the case were submitted last week, and we're waiting to see whether or not there will be oral arguments in the case. Just one last brief example, and this is a California case about a dispute over sea level rise rates used by the California Coastal Commission when setting permit conditions for building along the coast. So here it's the city of Encinitas, and the commission in this case established a condition of construction. So a single family home had to be set back 79 feet from the edge of a coastal bluff. And that reason was based on projected rates of sea level rise and the risks associated with coastal erosion and the viability and safety of the structure. So the homeowner challenged this, this condition of the permit. They offered a geotechnical consultant who asserted that the rates of sea level rise used by the commission were too high. So there was really a direct dispute about climate science and what rates of sea level rise were appropriate to determine the setback limit. In the end, the court agreed with the commission. It relied on an earlier similar decision in 2019 to find that the conditions were supported by sufficient and sound science. I'd just like to also offer some additional resources here if you'd like to go a little bit deeper. You can see a few here. And I also just want to quickly recap a couple of things, a few takeaways from today. First, more climate impacts, as John outlined, is likely to mean more cases. And some of these cases will involve climate science, either directly or indirectly. And as with any emerging area of law and science, there's resources available to ensure that the judges are prepared for the growing number of cases in this area. And now I'd just like to turn it over to Justice Duncan, who will tell us a little bit about her experience with the Climate Judiciary Project.
Yes, thank you, Jared. And I'll lead off with those key takeaways. First, my name is Rebecca Duncan. I'm a justice on the Oregon Supreme Court. I'm happy to be with you today and grateful for the opportunity to speak at this webinar. I'm here to share my experience with the Judicial Leaders in Climate Science program. I participated in that program in 2002. As Helene mentioned, the program reaches out to the chief justices or chief judges of jurisdictions to arrange for participants. And my chief justice asked me to participate in the program, and I did that. And my reason for doing so was simply straightforward. As a judge, I have an obligation, as all judges do, to continue to educate myself about the law and legal issues so that I'm prepared to handle the cases that come before me and my court. And I was aware, as all of you are, that climate-related cases were increasing in number, as Jared just explained. We've seen an increase in climate-related cases in our jurisdiction across the country and throughout the world. And that is something that we know as judges and lawyers happens in the law. As there are changes in society or the economy or the law itself, more cases of certain types come to the courts. And so we need to prepare for those types of cases. And I was also aware that climate-related cases present some novel and complex issues, also some management issues. Some of these cases may involve complex court case management. And so with that awareness, I participated in the JLCS program. And the idea was simply to learn what was coming to courts in a general way. As a judge, of course, my primary interest is in the law, and my approach personally is a practical one. What I wanted to know is what climate-related cases are coming to the courthouses, particularly in my state. I sit on the state Supreme Court in Oregon, and I was particularly interested in finding out what types of cases would we see in a state jurisdiction with the geography that we have here in Oregon. So when you think about climate cases, you might think of some of the cases that Jared mentioned. You might think of certain categories of cases, like administrative cases. Or you might think of cases brought in certain jurisdictions, federal jurisdictions, as opposed to state jurisdictions, cases brought under federal laws like the Clean Air Act or the Endangered Species Act. Or maybe when you think of climate-related cases, you think of high-profile cases, asserting a constitutional right to a clean and healthy environment, like the health case that Jared mentioned. Or maybe you think of big tort cases brought by individuals or governments against large energy companies. Certainly, though, there are those types of cases. And as a judge on a state court, I might think, well, I might not get a lot of those cases. Maybe there will be few or far between. But what we're aware of is that climate cases are increasing not only in number, but in variety. And they take, as Jared was explaining, new forms and different forms as people are responding to observed and predicted impacts of climate changes, observed and predicted changes. These are going to generate cases. So the question is, what do courts need to do to prepare for the cases that are coming? And of course, we will continue to see the administrative cases, the constitutional cases, the torts cases against energy companies. But we are already seeing other types of cases. For example, the Maui wildfires led to claims brought against utilities for failing to prepare for increased risk of wildfire that arises from climate-related conditions. You're seeing insurance companies suing governments, alleging that the government did not properly prepare to manage stormwater that is increasing when we have increased rain events, and they're attributing that to climate change. You have, like Jared also mentioned, more common claims arising from events like hurricanes and flooding that are going to be coming to our courts. Some of these cases will involve more climate science, some of them less, but we're going to get more cases and more climate science related cases. Again, the variety includes things that we might not normally expect or anticipate as categorized as climate cases. We are seeing, as Jared mentioned, cases brought against companies, saying that the companies are not correctly assessing or reporting climate-related risks to investors. Or you have pension funds, on the other hand, you have pension funds that have divested from energy companies, and they're being sued by pension holders, saying that the divestment has been a breach of the fiduciary duty. So there's a whole variety of cases that are coming to the courts. You might think, well, is there any area that these cases, these issues aren't going to be present? And you might think, well, what about in a standard domestic relations divorce case? Well, perhaps the property values are at issue because a property may have increased flood risks and be overvalued, and there may be a dispute about how increased risk of flooding, how likely is that? How does it affect the value of a particular property? So I think we will just continue to see more and more varied ways that climate-related claims are coming to our courts, whatever our jurisdiction is. So we know these cases are coming. We know they're here and that more are coming. And the question for us is, how do we prepare as judges, or as how do we fulfill our judicial role and our obligations to be competent and diligent, to understand the information that's presented to us and to engage with issues, some of which may be novel and complex, and to manage these cases efficiently? What do we need to be aware of? How can we manage these cases? And one of the things that we can be aware of to help us prepare are the resources, which John and Jared mentioned. So there are the climate case databases. So if you are interested in educating yourself about, well, what are the types of cases that are coming? what are the ones that are likely to come in my jurisdiction? We can look to the Saving Climate Case database. You could search Westlaw, but there's more efficient ways to get this information because people have been gathering the climate cases into these databases so that you can look and see what the trends are. Beyond just the types of cases, we can educate ourselves by using the modules about basic legal issues and basic science that CJP puts together and that John and Helene introduced. From the legal front, we can be aware of recurring issues. Several types of these cases have issues that arise frequently. They can be subject matter jurisdiction questions. They can be questions about standing or state and federal preemption. What types of claims, as Jared was mentioning, are proper for state courts as opposed to federal courts? These issues come up in a lot of cases. And so knowing about those issues and knowing that they're likely to come up in certain types of cases can help us know that we need to, basically go and make sure that we are current in our understanding of the state of the law on these relevant issues in our own jurisdictions. So knowing what's coming can help us go back and prepare, refresh our understanding of the law that we'll need to apply in our cases. And we can also have a basic understanding of the climate science. Climate science is a specialized area, just like areas of medicine, just like areas of finance. As judges or lawyers, when you're working in an area of specialized knowledge, we need to be able to read and understand the information presented to us, whether that's in medical reports, psychological reports, forensic reports, financial reports, business records. These types of specialized areas require us to have basic literacy in these areas so that we're familiar with the terminology, so that we can understand how the studies are done and the information is reported. And why that's particularly important, as I'm sure all of you understand, is that for judges and lawyers, many cases that are climate related will involve questions about the admissibility of scientific evidence. And as judges, we need to make rulings regarding the admissibility of scientific evidence. And as lawyers need to litigate those issues. Now, the rules governing the admission of scientific evidence vary from jurisdiction to jurisdiction. If you are in the United States federal courts, you're operating under Federal Rule of Evidence 702. If you're operating in state courts, you may have an identical or similar rule. But among the requirements of Federal Rule of Evidence 702 is that the testimony, a court can admit expert testimony on a scientific issue if the testimony is based on sufficient facts and data, if the testimony is the product of reliable principles and methods, and if those principles and methods are reliably applied to the facts. And so judges and lawyers have to be able to understand information so that they can assess what constitutes sufficient facts and data or reliable principles and methods, or the reliable application of those principles and methods to the facts. You're probably familiar with the Daubert factors or the Fry factors, which are taken into consideration when courts and jurisdictions decide whether scientific evidence is admissible. Those factors include what's the rate of error for a technique? Is the rate of error acceptable? So as judges and lawyers, we need to be thinking about, well, how do we assess what the error rate is with particular types of methods? How do we understand whether the error rate is acceptable? I think it's helpful if we're thinking about these questions in advance when we know that climate science related cases may be coming to our courts. So how do we educate ourselves? As judges and lawyers, we are trained and accustomed to thinking very critically about information that's presented to us. We've done that throughout our training and throughout our careers. We know how to assess and question evidence. We look at the source. We ask about the perspective. We think about how we know whether it's reliable. We do this Trial judges do this on a daily basis in their courtrooms. These are the approaches that judges and lawyers can bring to assessing the information that they're looking to when they're educating themselves, and then of course assessing the information that's presented to them in the courtrooms. So the idea about my participation in the Judicial Leaders on Climate Science program was simply that I wanted to prepare myself about how to do my job, recognizing my duty to be an impartial, competent, diligent decision maker. How would I understand the many and complex legal issues that might come up? And how would I have a sufficient understanding, and how would my colleagues have a sufficient understanding of science, so that we can make the rulings that we need to make? This is just what we would do with DNA evidence, with neuroscience evidence, any other field. So, the other thing that is beneficial about thinking about these types of cases in advance of when they come to your courthouse is recognizing that some of them may present challenges for case management, either because of the size of the case or for the very specialized information that's involved. Some courts, for example, have water law. There's some jurisdictions have water law courts. Water law issues are increasing, and some jurisdictions have formed special courts. Some jurisdictions have designated certain judges to handle these cases because they have developed expertise in these legal areas and are knowledgeable about the science. Some jurisdictions are thinking about or have court-appointed experts assist them on scientific issues. These are all procedural mechanisms that a jurisdiction should think about when thinking about how to prepare for cases that are coming. So as I mentioned, I attended the program in 2022 and came back to Oregon, and at the request of my Chief Justice, relayed information that I learned in the program to the judges at our annual state judicial conference this past fall. And the goal of my presentation, the panel's presentation, was to introduce the judges to the topics that we've been talking about here today. Our focus was practical and local. We wanted to present information about the observed and predicted changes in climate in Oregon in particular, and how those observed and predicted changes might affect the types of cases that are coming to our courthouse. So we put together a panel, including the director of the Oregon Climate Change Research Institute, which is a institute that was created by our state legislature to monitor changes in our environment in the state and provide information to the legislature itself and other policymakers and people in the state. So we wanted someone to come and present information about local trends. And we wanted that information to be particularly relevant to our state judges who are attending. We also had Jay Austin from the Environmental Law Institute come and present information like Jared did, talking about the trends overall across the country and around the world in this area. And then we also had a law professor from the University of Oregon who could talk about what cases, the types of cases we were seeing in Oregon and might continue to see given our particular geography. So all of that was done with the goal of educating judges about the types of cases and legal issues that may be coming to their courthouses, all with the goal of helping us be prepared to diligently, competently, and efficiently handle those cases. So that's been my experience, both as a participant in the trainings and then bringing a presentation to my local jurisdiction. And I'm happy to take any questions at the end, but I'll turn it over to Joy, who's with the National Judicial College, which was a partner in the program that I participated in.
Thank you, Justice Duncan. I'm the Chief Academic Officer at the National Judicial College, and I just have a few words to say to underscore the importance of this topic and to let you know why we are a partner with ELI on the Justice Leaders in Climate Science initiative. Our mission is to make the world a more just place by educating and inspiring its judiciary. So we've been doing that for more than 60 years and have built a reputation as a nonprofit and nonpartisan provider of high quality judicial education. We're reaching about 10,000 judges every year, and lately few issues have been more important to judges than the topic of scientific evidence. We offer several courses for judges on evidence, including an upcoming 4-day course, Advanced Evidence, that's going to be available online in November. We also offer webinars periodically and publications, including our Science Bench Book for Judges. So I encourage you to go to our website, judges.org, to see those resources that are available for judges. So our partnership with the Environmental Law Institute is a continuation of our commitment to educate judges on scientific evidence. In 2020, the Conference of Chief Justices chose the theme of environmental law for its mid-year meeting. And at that meeting, we heard from the chiefs that NJC could play an important role in helping to provide education to judges on this topic. So we reinstituted a 4-day course on environmental law for judges, and we also entered into the partnership with ELI's Climate Judiciary Project to deliver the program that you've heard about today. In all of our programming, we zealously guard our reputation to provide balanced and nonpartisan content. We recognize that we are in an era of heightened scrutiny of the content of educational programs, and we have a commitment to our faculty and our judge students to make sure that our curricula will withstand inquiry. That being said, knowledge is not bias. Judges have an ethical responsibility to hear cases competently. We believe judges will increasingly be called upon to weigh scientific evidence in climate-related cases, and it's our responsibility to offer education and resources on the topic. So we recommend the resources, excuse me, available through the Climate Judiciary Project, and please I encourage all of you to continue to take advantage of the educational opportunities offered by the National Judicial College, through the Climate Judiciary Project, and through the Berkeley Judicial Institute. So I want to give a shout out to all the lifelong learners on the bench, and now it's time to get to your questions.
Thank you so much to all of our presenters and for all these partnerships, which really are wonderful. So far, there's only one question. It's a really easy one, I think. So someone had asked the name of the Hawaii case that has a cert petition pending. And so the name of the case is the City and County of Honolulu versus Sunoco et al. It is a number of oil companies. Sunoco is in the first position. There's actually 2 petitions at the Supreme Court for review. The oil companies divided them into 2 different petitions. They're consolidated into one, but the numbers on the petition are cases 23-947 and 23-952. And Jared will tell me if I'm wrong, but the op certs just came in this week. The petitions had already been filed, so that means that there should 14 days, I think, until they can file a reply and be distributed for conference. So we should know if the Supreme Court will be taking that case up. I have not charted it on the distribution schedule, but sometime in the next 2 to 4 weeks or so. Although of course the court can always decide to not decide whether it's going to take the case for a while, but soon we should know if the court is going to review that case. You know, some folks probably do have to drop off at an hour. We do have 75 minutes and we are available for questions. If folks have them, we would be happy to answer them.
Can I ask a question of Justice Duncan? Can you talk about putting a local program together? Sort of what were the challenges? What were the victories? What were the things that you don't tell people necessarily? Taking, I think, the point of view of if another judge or justice wants to do something local, what lessons were learned from the program that you put together?
What I had heard from other participants in the program who had already done presentations in their home states, it was that the judges that they had presented to were most interested in the information coming from scientists with experience in their own jurisdiction. So we had a cohort member from Delaware who, when he did his presentation, said that the person who got the most questions at the end that people really wanted to talk to and get the most information from was their equivalent of our climate research person. So people really want the judges in his experience, and then I would say it was the same in mine, really wanted to hear from experts regarding the science, the climate observed changes that were going to affect people in their particular jurisdiction, because the effects that the climate changes that people are observing in temperature, in precipitation, those can have different effects depending on your geography, and people are very interested in how these observed changes are affecting their local agriculture or land use policies, things like that. And so it was important to us, based on that recommendation, to have someone, and we were very fortunate to have someone who was willing to come and talk to judges, and very excited to share the science with judges about what they know, also very importantly, what they don't know, and what they could relay to judges about the state of the science, and particularly locally. And so I think it was important, and I recommend getting folks from your local jurisdiction to talk about the observed changes in your jurisdiction.
And we have a question in the chat. How are all of you bracing for the Supreme Court decision in Lober, the potential overturn of Chevron? And I'll turn that to Helene, because she was the moderator and I just did an unfair thing by popping a question she didn't have a chance to see, but I didn't. So go ahead, if you would.
I'm actually gonna do the same thing I did, but he knows I'm gonna do it. I'm gonna send that to Jared. But I think that, to preview what he's going to say is that that decision is poised to have an enormous effect, not just on environmental regulation, but regulation all across the administrative state, all across our government. But Jared, do you want to say anything more specific about the relentless and local break cases?
I think we're just sort of waiting, like everyone else is, to see when and what the decision is when it comes down. I mean, of course, we're interested and we'll be looking closely for that decision. But at the Climate Judiciary Project, we're focused on looking at how science and climate science is coming up in the cases. I have looked at those briefs, and not a lot of necessarily climate science involved in the resolution of that case and that issue. So, we'll be looking at, how I think the implications for that case will take some time to understand and will unfold over the course of the next several months and years. And so I think we'll just be watching and waiting and seeing how it happens, just like everyone else.
I think that
would additional information be available on your site should that changes be made? There would be a softball question there.
I think that I think on probably not on CJP, but on eli.org, the Environmental Law Institute certainly is tracking that. And I think that the one thing that I thought of in Jared's response that I think is important is when Jared went through his nesting of cases and how much, and actually Justice Duncan really hit this home with her list of how much climate is impacting all sorts of litigation and all sorts of claims, we could actually pull it sort of back out. And that while those cases may be unbelievably important for federal regulation on the environment and other issues, that doesn't actually mean that there's not going to be climate science coming to the courts on all sorts of other claims, like all the other types that Jared spoke about and that Justice Duncan spoke about too. So I think that while it is, as watchers of the court will say, it's obviously a very important case when it comes to the regulatory state, it is also does not sort of change the fact that climate science is going to keep arising in the courts in all these different ways, as it is having such a big impact on all of us, on businesses, on everyone at this point.
Yeah, I'll just underscore one more thing. So sort of building on what Helene said, maybe outside the context of the Climate Judiciary Project, but very much within the context of the Environmental Law Institute, we will be having and engaging in this conversation after the release of the opinion, where we hope to be publishing actually a report very shortly that covers some of the ground looking at the history of Chevron and the current decision, and the arc of the US Supreme Court over the past 50 or so years. So, stay tuned for that publication and stay tuned for additional conversations at ELI around the topic.
Then I will let Helene take a moment to close, but I will give an unsolicited suggestion that all of you consider bookmarking the CJB site, the ELI site, and of course the Berkeley Judicial Institute site. But I want to say thank you on behalf of our audience and behalf of Berkeley Judicial to all of you for a thoughtful, engaged, and really interesting conversation. Very grateful that you all spent time with us today. Helene, any closing remarks for the group?
No, I think that does it. And I'm very grateful to all of you as well. And I want to thank Justice Duncan again for spending her Friday with us, and for Joy for joining us, and for BJI for hosting us. So please feel free. You have all the resources, and feel free to reach out. Like I said, we are happy to brainstorm and help, like Justice Duncan mentioned, find local scholars and scientists to help at your own events or to participate in them ourselves. And you know where to find us. So thank you all so much.
It's good work you're doing. Thank you so much for spending the time with us. Take care, everyone.
Thank you. Take care.